Hello, everybody. Welcome to our emergency webinar. It's a Sullivan on Comp presentation. My name is Mike Sullivan, and we're doing a webinar today on the executive order that came out from Governor Newsom a couple of days ago on May 6th. It's a big deal, and we do regular webinars. I've been doing them for a while. There's a picture of me with my contact info, and this one's sort of a special case. Just briefly, my name is Mike Sullivan. If you're listening to this, you probably listened to me before because we're putting out a series of these webinars. But I'm a defense attorney. I run a firm in California, which covers all of the California boards with 9 different offices. But today I'm wearing my Sullivan on Comp hat. Sullivan on Comp, if you're listening to this, you're probably a subscriber. If you're not, you should be a subscriber. The Sullivan on Comp is a comprehensive treatise which is used by thousands in California as a reference book for workers' comp law and in the state. We're really proud of it. We think it is the standard text in the industry for workers' comp. And today I'm wearing my Sullivan on Comp hat, which means that I'm not talking from the point of view of a defense attorney, but rather trying to do a complete exposition of the law. In this case, the executive order, what it means to people, to practitioners, what the issues are going to be, without trying to slant it in one way or the other. If you're listening to this, like I said, you've probably heard us talk before, and you probably got an email which gave you a copy of our book that we wrote on COVID-19 in California. Man, we are really proud of this book. It was really hard to do. It's really comprehensive for employers, and it covers employment law, workers' comp, even immigration, and it gives employers a complete guide as to what to do about COVID-19 in California. It's all lays out the law in depth. It's easy to understand, and it answers all questions. And if you print it out, it'd be about 200 pages long, but we left it in an electronic format because we're updating it virtually every day. This last week, we updated it and did a return to work section because we realized that was going to be an issue for employers. So if you if you don't have it, you can find it at sullivanattorneys.com. Save it to your desktop, look at it. If you have any questions on COVID-19 in California, this thing is going to help you. It will help you answer the question. Like I said, this is one of a series. Although this was done, we decided yesterday to do this one, and we've been running around like crazy getting it ready. It's just one in a series of webinars we're doing on COVID. Again, you can find it on our website, and it's made reference to in our book. And we're just burning through the issues. There's a lot of issues. There's a lot of things to think about. And so we're burning through them and going as deep as we need to go to get a full understanding of what the law is and what our options are as we move along. And we're giving you updates every week too on how this is progressing. And here's a list of the webinars we've done so far. You're probably going to want to go back and look at number 4, the duty to provide a claim form. That's the most frequent question I've gotten since the governor issued his emergency order is, okay, so what if I'm an employer? Do I now have to run down to the factory floor and give everyone I think might have COVID or a claim form? It's a big deal, right? For a lot of different reasons. I'm going to talk about it in depth here today. There's liability for temporary disability. We talked about that. We had a whole hour on that. People that have partial disability who are sent home with everyone else, should they get total temporary disability? And of course, TD plays a big role in the governor's order. And we're just starting on a series of webinars of when is COVID actually work related. We've done 2. We're going to do 2 more. The next ones are going to be on the psychological aspects of it. So we've gone pretty deep, and I think if you listen to these things every week, you're going to be pretty well informed about what the law is, what the implications are, what the options are, what the considerations are. And we're proud to continue to help lead the industry in dealing with this. The plan for our session today is to talk about the governor's order. It came out a couple of days ago, and man, it has really caused a lot of yelling and screaming. People have been urging the governor to do this, to issue an executive order to make workers' compensation presumptive for essential employees for a long time since it started. And there's several bills, and we'll look at them at the end of this webinar, and they are all proposing in one form or another that people that are on the front lines fighting the coronavirus, if they get sick, that there should be a presumption that it's workers' comp, that it's a work-related injury. And they've been asking, it's been taking a while, so people have been asking the governor to issue this presumption. He finally did it. It's not as dramatic as was initially suggested. For example, it's not a conclusive presumption, but it has a lot of really interesting features to it. There's a limited time period to deny a claim, only 30 days. The benefits are a little bit different. In some ways, like the TD, you have to have special proof to get TD. One wonders, like, how does this impact the duty to provide a claim form, whether the executive order is legal, and other presumptions being considered by the legislature. We're going to talk about all these today, and especially hit the points that we think are important to really think about in light of this presumption. I'm talking about provision of the claim form, how employers and employees should relate to one another, the 30-day rule, things like that. So let me get started and lay it all out for you. This is only the second of. This is not the first executive order that has been issued by the governor. There was an initial executive order issued on March 19th, and that's the stay-at-home order, when he told us all we have to stay home now unless we are essential employees and we're doing essential activities. And of course, I was heartbroken to realize that I was not an essential person because I'm just a lawyer. But the essential workers were allowed to go to work. All the rest of us are either furloughed or we have to work from home. In my environment, we're all working from home. I think it's pretty common. Thank God this happened during an electronic age where we can actually do that. But a lot of people are just out at work. It's pretty awful. I mean, you know this if you're watching the news, which you are. So anyway, the essential workers included healthcare workers, cops, EMTs, those working in the groceries and pharmacies, farm workers, people driving us around, taxis, truck drivers, postal workers, shipping workers, bankers, and gas station workers. And that's just a list, but it wasn't very well defined, right? So a lot of people are arguing over what is an essential worker. There was even, some people who had the mayor of Los Angeles at one point was shutting off power and water to those businesses who wouldn't shut down, because of course this is having a devastating effect on the economy. But anyway, except for essential workers, the governor's initial order said you have to stay home. This is the second of his orders, and this is the one that we're talking about today. So it was May 6th. It creates a temporary workers' compensation presumption for employees diagnosed with COVID-19. And the governor put out a statement and he gave a press conference and he explained why he was doing it. He was saying, look, there's people that are out in the world working while the rest of us are staying home. Well, they're taking on a special risk. And we don't really need people to be worried about contesting their workers' comp claims when they get COVID. These people, would be under the current system likely to be found to be entitled to workers' comp benefits. So we're just going to say, that there's a presumption that they do get it to help ease the burden of proof on them and get these things processed faster. The governor, he gave all the reasons you'd expect. He said employees who report to work while sick, increase health and safety risks for themselves and fellow employees. And he said this might reduce the spread of COVID-19. People will be able to stay home more. People will get access to medical care better if there's not a fight over their workers' comp benefits. And this is the rationale for Governor Newsom. I'm not here really to pass judgment on in this form on the advisability of this order. I'm here to explain it. But it's worth saying that there's a lot of people that have a strong reaction to this. I was watching the news. I'm reading WorkCom Central this morning, and there's, employers groups, Chamber of Commerce are all saying, hey, I don't know if you noticed over here, but we're all going out of business. And, the burden is so high on employers as well as the employees that something like this is going to be even more crippling than the things we've already experienced, especially if it creates a lot of claims that otherwise would never be filed, or which which really aren't work related. And we just have to pay for everything. We're already paying for everything, and we're going to go broke. They don't like it. They think that it's pretty easy. 90% of all cases are accepted in workers' comp, so they think it's unnecessary. But obviously, the labor has a different point of view. They feel like that we need to do. Eventually, they want a conclusive presumption, right? So, and for psychological injuries too, they want a conclusive presumption if they're related to COVID. But they do applaud the rebuttable presumption that the governor's presented because they feel so. People need to have these things streamlined. We need to limit the number of denials, and we need to just not mess around with people that are on the front lines that get COVID. So, we don't all agree. What do you know? Welcome to America, right? Now, the presumption itself is retroactive. All the way back to the date of the stay-at-home order, and will stay in effect for 60 days. So it's going to be in effect from March for employees working from March 19th, 2020 through July 5th, 2020. This is the effective date. There's a window. Governor's emergency orders, they have a limit, and they're there to wait out the time it takes for the legislature to take action in part. So, like I said, at the end, we'll talk about the pending bills that are out there, but what's likely to happen is there's going to be some kind of bill that will come in and replace the terms that are set out in this order by the governor. But in this window, March 19th through July 5th, there's going to be this presumption it's effective for employees that make a claim. So. Now, its application is a little tricky, and it's somewhat limited in scope. Like I said, it is a rebuttable presumption, and it doesn't apply to everybody. Essentially, it only applies to people that go to work. It doesn't apply to people that stay home. And there's four actual conditions, which I'll run through here. The first one is, got a whole lot of variables in it, and it's important to notice them right up front. One is that it says the employee has to test positive or be diagnosed with COVID-19. So note there's two things there, right? One is you can either get a positive test, in which case you get the presumption, or you can be diagnosed by a physician, in which case you get the presumption, right? It can be either or. But this testing or the diagnosis has to take place within 14 days after a day that the employee performed labor or services at the employee's place of employment and at the employer's direction. So there's a lot of variables there, right? A lot of things. So it has to be 14 days after a day that the employee performed labor or services. So if the employee didn't work, then it wouldn't apply within 14 days of getting it. So, if you got diagnosed or tested positive on the 15th, you didn't do any work since the 1st, then you're not going to get the presumption. The work has to be performed at the employer's place of employment and at the employer's direction. So, in place of employment. What that means is not home, and that's number 3 there, not the employee's home or residence. I'm imagining that people that are out in the field would be considered their place of employment. And then there's at the employer's direction. So it has to be labor or services at the place of employment at the employer's direction. So that means the employer said go to work, right? So let's say you send everyone home and someone just comes into work without being told to do so. Then that would probably mean that the presumption would not apply. So all these conditions have to be met, and it has to happen within that 14-day period. If 14 days have elapsed since you've been at work, then you're not going to get the presumption. So that's really the 4 of them. I've kind of overridden the last 3 by talking about the first one a lot, but it has to be within the 14-day period. It has to be the day on which the employee performed labor or services at the employee's place of employment at the direction on or after. It has to be on or after March 19th, right? Because the order doesn't apply until then. It can't be at home, and then the diagnosis or the testing has to be presented. Now, there's this last condition that says that the diagnosis has to be done by a physician and surgeon licensed issued by the California Medical Board. And then it has to be confirmed by further testing within 30 days of the diagnosis. So if you get the presumption because you got a test and you have COVID, then that's good enough. If you get the presumption because there was a diagnosis by a physician, that's okay, as long as it's timely and the other conditions are met. But within 30 days of that, you have to get further testing. You're going to have the testing. Otherwise, you're not going to have the presumption. So the testing and being found positive for COVID is a necessary part of it, at least at some point, in order for you to get this presumption. If it's just a diagnosis, then you're going to have to go get the test and show that it is COVID within 30 days, or the presumption goes away. Now, who's covered by the presumption? This is a key point. I think I got it wrong in the last webinar I did. It was on yesterday at noon, and we had just gotten this order and hadn't really had time to review it before we started talking about it. So we just spoke in generalities, and I talked about how it covered essential employees. It covers more than essential employees. It actually covers any employees who have to work outside their home. So anybody not working at home. And you say, well, everyone's been ordered to be work at home except for the essential employees. And you say, well, yeah, maybe, but there's sometimes a debate about what businesses are essential, right? And some businesses have stayed open, even though they're not essential. So anybody who's working outside their home, well, if they test positive within the 14-day period, then they're covered. So it's a little bit broader than essential employees, isn't it? And even if you are an essential employee, if you're working at home, it wouldn't cover you. The employee still must be diagnosed by the physician and have it confirmed by testing. And these are the employees that are covered. The fact that this is rebuttable and not conclusive is really important. There's only one conclusive presumption I can think of in workers' comp, and that's the 4662, where it says, you're 100% totally permanently disabled under some conditions as a matter of conclusive presumption. It's like loss of both eyes, loss of both hands, and other things like that. But there's a lot of rebuttable presumptions in workers' comp. You got, if you're late on your 90 days, then there's a rebuttable presumption, right, that the claim is compensable. There's a lot of presumptions in favor of public workers, cops, firefighters. These are also rebuttable, and it's important. It's an important difference, because a conclusive presumption means that the issue is decided. If you have COVID and you are a worker outside the home, then you have it, and that's it. It's work related, and you get workers' comp benefits. There's no going to court and arguing about it. You can't rebut it. It doesn't matter what the facts are. That's it. A rebuttable presumption allows an employer it gives the employer the burden of proof, but it allows the employer at least to try and contest it. So for example, if you had a whole workforce and no one got COVID except one person, and you knew that person's family all had COVID, you might be able to rebut the presumption, right? So at least under this, where it's clear that the COVID didn't come from work, well, then workers' comp wouldn't apply. So the employer has at least some ability to defend themselves. What do you use to rebut the presumption? Well, the executive order just says it's rebuttable by other evidence, which would mean anything. So there doesn't seem to be any limit on its face. Now, at his press conference, Governor Newsom stated that the presumption could only be rebutted under quote unquote strict criteria, but that's something he said at a press conference. It's not in the literal language of the order, so it's not the law. And no strict criteria are provided, and he didn't say what the strict criteria were. So I think it's just something that came out of his mouth. It doesn't, I would think, matter for purposes of trying to figure out what you can use to rebut the presumption. The administrative director has been given authority. If he wants to, he can adopt some regulations to help clarify the order. He also has been given authority to clarify the evidence that could be used to rebut the presumption. So maybe just a statement outside of emergency regulations might work. The thing only lasts 60 days. So one was given to wonder if there would even be time for emergency regulations. There probably would be time, but but wouldn't be much time left after they got enacted before the 60-day closed down. They might be needed, for a window period if there is legislation or this comes to an end for those employees who fell within the time period in question. So, the administrative director may be limiting this idea of other evidence, but for right now, you can rebut it with anything, any kind of evidence. Here's where it gets really interesting to me. They decided that the claims people out there in the world, they decided that they have to hurry up. Normally, if a case is denied, in a case claimed, you have 90 days to accept or deny the case. And in this instance, they decided it's going to be 30 days, not 90. You only have 30 days to investigate the case. That's not a very long time period. And one is given to wonder, like, how are you going to do this? And how's this all going to work? Normally, the 90 days is enough time to do depositions and QMEs and all that. 30 days isn't super long. And when does the 30 days start? Well, the answer is, at the time the claim form is filed. In fact, the 30 days are going to work just like every other part of it. Just like the 90 days works in exactly the same way, except for the amount of time that's allowed. So in a normal situation with the 90-day period, you do the investigation and you deny on time if you don't. And one of the things I ask lawyers, when I do some quizzes when I interview lawyers, is I say, how long do you have to deny a case? They say 90 days. I say, when does it start? And they say employer knowledge. And I say, wrong. It doesn't start with employer knowledge. It starts when the claim form is filed. That's very clear under the Honeywell case. The 30-day period is the same thing. It doesn't matter about employer knowledge. What matters is absent fraud, where there may be some estoppel, but it matters when the claim form is filed by the employee with the employer. That's when the 30-day clock starts to tick, which is an important point and a point that a lot of people don't know, but it's not unique to the 30 days. It's just the 90 days. It's the same as the 90 days. It's just you got to know that. It's when the claim form gets filed with the employer, not knowledge, that starts the clock ticking. Also, let's say your denial is late. Well, in a normal case where you had 90 days, let's say your denial is late. What's the consequence? A lot of people don't know the correct answer to that. Some people know that if you're late on your denial, then there's a presumption of compensability, right? But a lot of people don't always know is that you can't use any evidence you reasonably could have obtained in the first 90 days to rebut the presumption. And that's really where the teeth is, right? Because you can get all your evidence in the first 90 days if you're diligent. Depots, witnesses, QMEs, doctor's reports, subpoenaed records. They could all be got within 90 days. So if your denial is late, you can't use any evidence to rebut the issue of AOE COE that you could have obtained in the first 90 days. The same rule will likely apply for the 30-day period because you use the same statutory language, the same language in the order that they use in the statutory language. And it says that if you're late on the 30-day period, then it's presumed compensable and only can be rebutted by, quote, evidence only discovered subsequent to the 30-day period. That makes it seem like you could use evidence after the first 30-day period, but that's not the way it works because it's the same language that's in the statute for the 90-day period. And case law has interpreted that to mean you can only use evidence reasonably obtainable within the first, that is not reasonably obtainable within the first 90 days. So the same thing's probably going to apply, almost certainly will apply to the 30-day period. Look, there's a lot to this. You can read about it in Sullivan on Comp. There's a lot of, when cases are denied late, there's a lot of legal strategies and theories that can overcome some of these problems. And I've won cases with late denials on multiple occasions. But for purposes of this discussion, we just need to know it's the same as the 90-day rule, but it's 30 days, not 90. Now, look, this is pretty problematic. Okay. It's like, hey, how's this actually going to work? Does the 30-day investigation period apply retroactively? Because I don't know if you noticed, but claims already have been filed. Say that there was a claim filed on April 1st. Well, 30 days passed, on May 1st. So now this order comes out on May 6th saying you only have 30 days to accept or deny. And the claims people are going, well, wait a minute, I thought I had 90 days, right? All of a sudden there's this order saying I have 30 days. So that means that every single claim that was under investigation that was filed before April 5th it's already too late. You've already blown your 30-day denial period. And that doesn't seem right, does it? I mean, it doesn't give any leeway to claims people that are bushwhacked by this. What are we going to do about this? What's the answer? I don't have a clear answer. I'm sorry, but I don't. I think it's probably colorable. The literal language of the proclamation of the executive order is, look, it's 30 days from the date the claim form's filed. So that's it. You blew it. There's a presumption against you, and you can't use any evidence you could have obtained in the first 30 days. That's what applicants' attorneys will say. Defense attorneys will say, nah, this is a violation of due process because this was ordered after the fact. Courts may interpret it that way. I don't have an answer, but that's what I think is probably colorable either way. And in my opinion, it is. What happens if the presumption is not established until more than 30 days after the filing of the claim form? So the presumption, look, there's conditions for the presumption to be established, right? So think about this. They got to, in order for there to be a presumption in the first place, the applicant's going to have to make a showing. And I think this is the way it's going to end up working is a prima facie case will be required by the applicant, and then the burden will shift to the defendant. And once it's made, so they have to meet the conditions of the presumption. So they have to show that they weren't at home, they were out of work, and they were doing it at the direction of the employer. And it was within 14 days from the diagnosis or the test. And then they have to get it validated, right? If it was a diagnosis, within 30 days from that, they have to get an actual test. But what happens in the situation where they don't have the test within 30 days? What happens if the conditions of the presumption are not met until more than 30 days after the claim form is filed? So, if the testing isn't done within the 30-day period, does the denial still have to be issued within the 30 days? Because they haven't established the preconditions for the presumption before the denial period ran. There's probably no easy answer to that one either. I think it's safe to be safe. The employer is going to want to respect the 30-day period, but that certainly will be an argument that will go forward in some cases. And then here's the question I think is fair to ask: how can the employees possibly be expected to conduct reasonable discovery within 30 days? Deposing an applicant, what if the applicant's attorney can't give you a date within 30 days to do a virtual deposition? And, if you're going to rebut it, you may want to depose family members. And family members, they're not parties, so they can't just be noticed. They have to be subpoenaed, like physically subpoenaed. So they may not like that. And it takes time to get them served. And what if you can't serve them? And then what about subpoenaing records? That can take time. Subpoena records are busy. It's a convoluted environment. Look, QMEs, they can't set in that time period and get a report out, and or they're required to by law. So it's going to be tough on employers. And I think that's on purpose because they wanted to make it tough for our employers so that the decision will be made faster. It's, they don't necessarily want the employers to suffer or not have due process, but they want to make sure that the decision is made fast because people are sick and they need care, and for all the reasons underlying the order. But this is going to be a real challenge for the employers. Normally if you're an employer and you do things like set depots or other discovery and the applicant doesn't cooperate or won't sign, what if the applicant's in a coma and can't sign a release for records? What do you do then? You certainly can't blame the applicant. He can't sign the release. You can't deny for failure to cooperate with discovery, can you? Or maybe you can. I don't know. Maybe it's not a matter of the applicant being. So anyway, it goes. The issues go on, and it's going to be. We're all going to have to try and deal with this in real time, with real cases, the best we can, and fight it out in court when we have to. In terms of benefits available under this rule, under this order, All the normal workers' comp benefits are available. And we know what these are, right? There's just 5 of them: medical care, temporary disability, permanent disability, which sometimes includes life pension, the voucher, and death benefits. And that's it. That's all you get in workers' comp, unless you get penalties, I guess. And there could be increases of benefits by 132A and S&W, but those aren't benefits in and of themselves. So that's it. 5 benefits. If you have a work-related injury, you get those, and there's no difference in that because of this order. What had been proposed and is proposed in some of the existing legislation that's winding its way through the legislature is possible increases in benefits, housing, expenses for protection from COVID-19. These are being considered by the legislature, expanded benefits in workers' comp. It's the first time we've ever seen anything like that, really. Although before the limits of medical treatment were pushed pretty hard. I can remember building an applicant in a house one time. So, I mean, man, the governor didn't go there. The governor just left it alone. If you get this, you get regular workers' comp benefits. Another thing that has been proposed was that there be no apportionment in these cases. Where does that come from? Well, that comes from the cop and firefighter presumptions we already have. If a police officer has hypertension and then gets aggravated by work, then there's no apportionment of the underlying hypertension that pre-existed it. That's the way presumptions work in these cases, and they wanted it to work that way in COVID-19 cases too, and that is proposed again in some of the legislative bills, and the governor was asked to eliminate apportionment in these presumptive cases. But it isn't barred. The governor did not go there. Permanent disability related to COVID-19 is apportionable to other causes. Here's where it gets a little weird, is temporary disability benefits. The executive order says that where the employee has paid sick leave benefits specifically available in response to COVID-19, those benefits shall be used and exhausted before any temporary disability benefits or benefits under Labor Code 4850 are due and payable. Okay, so what that says is that if you have special sick leave benefits available to you because of COVID-19 diagnosis that you wouldn't have in other cases, you got to use those up before you get any temporary disability or 4850 benefits. Now, 4850 is that labor code that refers to full payment in some public employee situations. They get full payment for up to a year in lieu of temporary disability, but it's the same thing. It's workers' comp benefit, right? So if you get special TD or special sick leave, you got to use that before you get temporary disability. So, I think they're referring to the Emergency Aid Sick Leave Act, which provides for an extra 2 weeks of paid sick leave. That's a federal act that employers are implementing. It gives people extra sick leave. So that would replace temporary disability. Or if there's some other special sick leave that the employer is providing voluntarily to COVID people, then that would eliminate a TD during that same time period. So they're not getting double payment. I note that an employee cannot be asked to use his or her normal sick leave prior to entitlement to TD benefits. It's part of the law. You can't just say, oh, use your sick leave before you get TD. That doesn't happen. That's against the rules. Can't do that. No one is doing that. Excuse me. Don't worry, I'm fine. I just got a little talking too much. But anyway, yeah, so the normal TD is the normal TD unless there's special sick leave given by the employer, either compelled by the government or just voluntarily. Now, here's a really interesting part of this order, is that temporary disability needs to be certified on short time periods or you don't get it. And that is different than the situation now with TD. I'll tell you what it is. So it says that the employee has to satisfy either of these requirements. So if you're diagnosed or test positive going forward after May 6th, you have to be certified for temporary disability within the first 15 days after the initial diagnosis. And you have to be recertified for temporary disability every 15 days thereafter. for the first 45 days following diagnosis. So that first 45 days, you got to get certified every 15 days, or you do not get temporary disability. If you're diagnosed prior to May 6th, then you have to obtain that same certification. It's the same thing within 15 days of the order. So it's the date of the order, May 6th is it. If you've already got it or to get it in the future, it's either 15 days from May 6th if you already got it, or 15 days after the diagnosis if you don't. But what's interesting about it is, in regular workers' comp law, look, whether or not you get TTD or entitled to TTD is an issue of medical fact. If the employer wants to provide, avoid a penalty, then they're proactive about getting medical certification, and it's only required every 45 days, right? So you have a regular workers' comp case and someone gets hurt and they get TD and they go to the doctor. It's an initial exam, and then at least every 45 days there's a report. And if they're entitled to TD, they're entitled to TD. And if they don't provide the documentation, then the employer is going to go out there and try and get it themselves, because they have an affirmative obligation to make sure the benefits are provided where they're needed. And usually they'll want an order before they'll cut off temporary disability, because they don't want to get a penalty. So even if the employee doesn't provide the required documentation, or even if years pass and the case is later litigated and it's proven that TD was owed during a given period, then you got to go back and pay it. But this is different, not only in the shortened period every 15 days, but it seems to say you don't get the temporary disability at all if you don't get the documentation, and that's put on the employee. So being diagnosed with this and having the presumption doesn't automatically entitle an employee to TD benefits. And this is only for cases that are under the presumption. So presumably the regular TD process will be followed if there isn't a presumption. And of course, the preconditions for the presumption are the applicant's responsibility to prove. So it's another layer of complexity. It's strange to me that they're doing this. It seems they want to put some of the burden back. Since they're doing this to employers, they want to put some of the burden back on the employee to provide the documentation that TD is needed. I wonder if this could be proved, if this actually will be taken at its word by the courts. I mean, if the documentation isn't provided, but it's later shown that the applicant was TTD during that time, will the courts actually say the applicant does not get temporary disability for that time period? It seems pretty clear that if documentation is not provided and benefits are not provided, that the employer should not be penalized under this language. The literal language would seem to imply, well, I would actually state that TD would not be paid, even if later on it was established that it was needed. So it's easy to see, for me, a lot of my clients just providing it if it's proven that the TD was owed during that time period, because a failure to provide benefits in the system can really get you nailed in terms of penalties and the scrutiny of the audit unit. But that's not what this says. So. And it's so weird that if you didn't have the presumption, probably this isn't required. So I don't know. There's a lot of issues here too. If you're an applicant's attorney, you're going to want to make darn sure that this documentation is provided. If you're an employer, you're going to want to really consider whether you're going to provide temporary disability and how proactive you think you need to be if the documentation is not provided, to make sure that the applicant gets the benefits that they'd otherwise get. But it's a whole different structure than what we're used to with temporary disability, a whole different set of duties and standards. And so it's going to have to be well considered by all involved. And finally, there's death benefits. Now, we talked about this in past webinars, but the thing about death benefits is, like anything but apportionment, they're not apportionable. So if you have a non-industrial and an industrial conditions that work together to cause a death, it's compensable. So if you get industrial COVID-19 and it aggravates a non-industrial condition, say a heart problem, and you die, it's compensable. If you have a compensable heart problem and you get non-industrial COVID-19 and that industrial heart problem is already work-related and you die, it's compensable. So as long as the employment is a contributing cause, then death benefits are compensable. The executive order states that the Department of Industrial Relations shall waive collection on any death benefit payment due pursuant to the labor code arising out of claims covered by this order. So what it's saying is, normally if there's a death, then the dependents get paid money. right? But if there's no dependents, the state of California gets paid up to $250,000. The death without dependents unit enforces that and will go to trial if need be in order to get that money. But the executive order is waiving death benefits covered by this order. So that means that if there is a presumption and there are no dependents, the state of California does not get its money and will not even pursue getting its money. What if there is a presumption? What if there's not a presumption? Then the state of California order to stand down there too? It's not clear. It seems like this only covers presumption cases, right? So they could have the weird situation where if there wasn't a presumption under this order and then there was a death, then the state of California could pursue the death benefits. So they could be in the position trying to argue that there wasn't a presumption while simultaneously trying to prove that there was a work-related COVID case. So again, another oddity, another issue that is going to have to be dealt with going forward. Now, this is probably the most important part of the presentation that I know of. It's the duty to provide a claim form. This is by far the most frequently asked question I've gotten. When do you have to provide a claim form, and do we have to provide a claim form now that the governor has said that there's a rebuttable presumption in favor of it? I'm going to argue with myself about this if you don't mind, because I've been arguing about it with attorneys in my firm, and I think that there's going to be a lot of argument about this. And when I consult with my clients, I'm going to have to make sure they understand the subtleties of the rules and what they may mean for prospective actions. My clients say, look, I have a factory, 40 people on the floor have COVID or COVID-like symptoms. Do I have to run down and give them all claim forms, even though they haven't said it's work-related? What is the answer to that question? Now, I want to point out that we've done a webinar on this, and we spent a whole hour talking about it. When should the employer provide the claim form? There's the legal standard of when you must provide a claim form, and then there's other considerations about whether you should or would choose to provide a claim form. No one wants to be the person that's the bad guy, and we're all supposed to be pulling together in the time of crisis, and no one wants to be perceived as that kind of company either. There's PR considerations, there's human considerations, and so all of that will have to be taken into account, and the judgments have to be made carefully by each individual business owner in light of their overall circumstances, and there's just no way around that. It's a very tough thing to figure out and to decide, and there's a lot of unknowns no matter what you do. But we can be clear about what the legal standard is, and I want to do that. Like I said, if you're going to make this judgment, I do recommend you go back and listen to that whole hour webinar because it covers it in depth. But I can tell you essentially what they said and what the parameters of the decision-making process are going to be in light of this new executive order. So what is the legal standard? When does the employer have to provide a claim form? And the answer is not very often, a lot less often than I think just about everybody thinks, or a lot of people think. And the foundational case on this is Honeywell. This is the same case that established that it's the provision of the claim form by the employee and not the date of knowledge, which starts in 90 days ticking. Very same case. It's a very conservative case. And the California Supreme Court held that the employee's duty to provide the claim form arises when the employer has been notified by the injured worker in writing of the injury or has knowledge of the injury or claim from another source. What that means is that you either have to have an applicant saying, I'm making a claim now, I have a work-related injury now, right? If the applicant makes that clear statement, then yes, a claim form must be provided. Or if the employer has knowledge, but what is knowledge? And that was the key controversy in Honeywell. When does the employer know that there's a work-related injury such that a claim form must be provided? And it's shockingly conservative. If you look at the facts of Honeywell itself, what happened is the wife called the employer and said, my husband is entering a psychiatric hospital. His work supervisor and others have pushed him to the edge with their head games. Now, Is that knowledge? Did she just make a claim? She didn't say I'm making a workers' comp claim. She didn't say my husband has a workers' compensation claim. She didn't say give me a claim form. But she did say he's going into a psychiatric hospital and he's been pushed over the edge by your head games. That to me, intuitively would sound like someone is telling you I have a work-related psychological injury, or the employer would be informed of that, right? And the lower courts had decided that did mean that. And they said as long as the employer had a reasonable certainty of a work-related injury, well, then they had knowledge. But the California Supreme Court reversed and said, no, the employer did not have knowledge in that case. Even though the wife said, he's tired of your head games, he's going to a psychological hospital, that is not knowledge. The employer has to know, not reasonable certain, but know that there's a work-related injury. Like we saw the bench fall on his head kind of thing, right? So the standard is really, really high for employers. Now, look, the system hates this. The auditors and the judges hate this. They don't like this, but it is the law. And I pointed out in my last webinar that some regulations actually seem to try and water this down. But I think the law is very conservative on when an employer has to provide a claim form. You have to know it, and you have to know it, not be reasonably certain. So, one can envision in the present environment a lot of scenarios where the employer might argue that they didn't know under the Honeywell standard, right? Someone is working in an area and has COVID, and then the other people in that area get COVID. Are you reasonably certain that it was caused by, affected by the sick person? Yeah, probably. I mean, a reasonable mind would think that happened. Do you know it under the Honeywell standard? Arguably, you do not. So it's a very high standard. Now, here's an argument that would say that the employer has to provide the claim form. The purpose behind this order is to remove the burden from workers on the front lines of proving their case. The governor says these people risk their health and safety to deliver critical services. And they risk themselves. And we're not going to throw the burden of proving that it's workers' comp on people where pretty clearly under the law they would be entitled to workers' comp. They are different than the general public. And that is the standard of proof, as we've discussed in past webinars. This excuse order is intended to protect frontline workers. So not to provide the claim form would contradict that intention. And they need to be advised of their rights and given a claim form. The argument that the executive order doesn't change the duty would say, look, something along the lines of, this argument is, this presumption goes to proving of the injury as industrial. It does not go to the employer's obligation, it does not say anything about when the employer has knowledge or doesn't have knowledge. If the applicant wants to file the claim, then that presumption may apply, and that's where it belongs. But there's been no order by the governor that pertains to what constitutes employer knowledge of injury. As an example, suppose a cop has hypertension. If a cop mentions to a supervisor, hey, I have hypertension, the employer is not under obligation to provide a claim form just because it's possible or even likely that hypertension was developed or aggravated by work conditions. No, the claim form doesn't have to be provided in that situation, right? Because the employer does not know under the Honeywell standard. But I was talking to one of my old clients this morning. He said, boy, I wouldn't want to be the employer who said no to providing claim forms to people in this situation. And there's that. I mean, it's a big identity question for every employer. And there's also a lot of very variable circumstances. There may be people, that pretty obviously don't have it from work, and you don't want to go down and give everyone a claim form, because that's what employees do, is they fill them out when they're given a piece of paper by the employer. They tend to figure it out, and if they don't understand it, instead of asking people, and then they fill it out. So this is why the employer community is screaming. They're going to say everyone's just going to file a claim, and then everyone's just going to get it, and it's not going to matter whether it came from work or not. And that's not fair, and it's an undue burden on not just the employers but the whole economy, which is already suffering. So these are the parameters of the debate, folks, and these are the parameters of the decision that's going to have to be made by each employer regarding provision of the claim form. It might be the most important, or one of the most important decisions that employers make throughout this entire process. And I recommend that you do it calmly, thoughtfully, with the advice of counsel, and in a documented fashion, and continue to be open to revision in the event of change or evolving circumstances. Is this executive order legal? Well, probably. I mean, look, we just saw how some people are put in an impossible position by this. Some claims are already 30 days old, even though this thing has just got enacted, right? Is that a violation of due process? And some employers would question its legality. We looked at the Constitution, and it says the legislature is hereby expressly vested with plenary power, unlimited by any provision of this Constitution, to create and enforce a complete system of workers' comp. I mean, that puts the workers' comp system in the hands of the legislature. Boy, after all the reforms, the applicants' attorneys tried to say this is unconstitutional or that's unconstitutional. They lost because the court said, look, the legislature has plenary power to control what happens in workers' comp, right or wrong, fair or not fair, doesn't matter. You lose, applicants' attorneys, and in just about every single constitutional challenge to SB 863 or SB 899, they lost because of this plenary power provision. So here comes the governor doing what it is in the province of the legislature to do and control. It says, look, it says unlimited by any provision of this Constitution. This plenary power rests in the legislature. So the argument could be, and probably will be made, that this executive order in and of itself exceeds the scope of the governor's authority. I mean, there's a lot of bills being considered, right? And they could be on the governor's desk expeditiously if the legislature chose to act that way. But arguably, the governor usurps the legislature's plenary power in issuing this order. However, there is a lot of reason to think that this is okay. There's a whole scheme of emergency services, a California Emergency Services Act, which gives the governor broad powers. He can, to declare a state of emergency, which he's done. It visualizes extreme peril. Epidemic or disease is actually listed as that one possible extreme peril. And so, like a state of war, right, or something like that. So it gives the governor during these times of emergency to suspend statutes, any regulatory statute or statute prescribing the procedure for conduct of state business, or orders or rules, regulations of any state agency. You can suspend, which is effectively done with this order. He suspended a whole series of statutes. I mean, the government code says this. He has this power during an emergency. And he has complete authority over all agencies of the state. Now, he just told us that the administrative director could define the scope of proof for rebutting the presumption, right? He could just do that. Normally, the administrative director has to do emergency regulations, or it's invalid. He can't just say what we're going to do as a matter of law, right? But the governor can do that. He has complete authority over all agencies of the state, and the right to exercise within the area designated all police power vested in the state. So by the Constitution, in order to effectuate it. So the governor is deliberately given by the legislature this government code, which during the state of emergency gives very broad powers, and he's used them. It seems to me that, well, it will seem, I'm not going to say what I think, but the argument will be made, look, this is what was passed by the legislature. They gave the governor this power. So that means that the legislature did sanction the use of this power in a crisis that involved workers' compensation. I don't know. We're going to fight about it. But it only may make a lot of difference retroactively, and it may not make a difference retroactively, depending on what legislative options actually come to fruition in the months to come. An executive order can only be in effect for 60 days. So the legislature has a limited time to end the state of emergency and to pass a bill regarding a presumption. An state of emergency can be ended by a concurrent resolution of the legislature declaring at an end. So the legislature can come in and put an end to the state of emergency. So we're going to know something in 60 days, one way or the other. Either this will expire, or the legislature will have replaced it, or the legislature will have done nothing. I think House money is on the legislature passing some sort of presumption. But what will it look like? And if it doesn't directly mirror all the provisions of this order, what will be the implications of the order going forward? That's pretty complicated. Like, let's say, for example, they don't have the temporary disability provisions in whatever legislation appears, right? During this window period, will that order apply? And so will this burden of proof on employees still exist? Only in presumed cases, right? Or not? Well, we'll have to see as it goes along. And of course, we'll analyze whatever comes up, and we'll present you with the scope of the legal possibilities and the options for action going forward. I'm going to just briefly here at the end show you what bills are out there. There's 4 of them. 2 of them are the most relevant, and one of them is the big bad bill from the employer's perspective, and the just and fair one from the applicants. That's AB 664. Now, AB 664 would create a conclusive presumption, and we talked about what that means, right? Defense loses, that's it, no argument. For firefighters, specified peace officers, and some healthcare employees who provide direct care in an acute care hospital, not direct care of COVID, mind you, but just direct care in an acute care hospital. It would also include entering into a quarantine as a legitimate workers' comp claim, which is weird because there's no injury, right? So, okay, if you're in quarantine, then you can have a valid workers' comp claim. But what would the benefits be? There's no medical benefits because you're not sick, right? There's no TD because maybe there is TD. Maybe you're at home but TD usually requires you to be temporarily disabled from work. So it's not clear if that would actually be a situation where TD would be provided during the period of quarantine. But this is the bill that included all the other reimbursement proposals: emergency equipment or personal protective equipment, reasonable medical expenses relating to protection. So palliative care, like preventative care, would be allowed as not in workers' comp. Living expenses, housing, these are all benefits that would be created by this bill as part of workers' comp and would be given to people in quarantine if it was passed. So that would be a radical departure from everything workers' comp has been about in terms of giving benefits since 1918 when it got invented in California. And also, this bill would amend labor code section to eliminate apportionment under that statute. So any cause of injury, not prior awards, but just like the other presumptions, like I was saying before, if there was a cause of injury that wasn't work related, you couldn't apportion permanent disability to it. So there'd be no apportionment at all for these types of cases. The other bill is not as comprehensive as that. It's Senate Bill 1159, and that's at the Senate. And this one would be a rebuttable presumption, not conclusive, covering critical workers who directly interact or previously directly interacted with the public. So that's not even essential workers, but the term is critical workers. That's defined as a public sector or private sector employee who is employed to combat the spread of COVID-19. That's not all essential employees, so it's a much smaller scope. Doctors and nurses would qualify if they treated COVID-19, but it's unclear if cops, firefighters, or janitors, are employed to combat the spread of COVID-19. That would be unclear. So this is a much more limited scope, and it has conditions on compensability. It has to develop or occur during a period in which the critical worker is in service of the essential critical infrastructure employers. So the injury has to develop during that time period. It's confirmed by a positive laboratory test if it's available, or diagnosed if it's not. It would have to result in hospitalization or significant time loss beyond the work shift. We don't have the number of days yet that they'd have to be out, but there have to be some days they'd be out, and it's rebuttable by any other evidence. And so this is a much more limited in scope, and it would have an automatic unspecified right now repeal date. I mean, in recognition possibly that, as COVID-19 gets more and more prevalent and more ubiquitous, it may not be needed or worthwhile. The other two bills that are left are bills that were kind of in the system already, and they may serve as sort of skeletons for a more substantial bill as the proceedings go. One was rebuttable presumption for hospital employees. They've been trying to do this for teachers and hospital workers for a long time. They've been vetoed quite a bit. For certain types of diseases, there would be a presumption for these hospital workers, but that's all it's provided. It's not directly relevant to COVID, but it may be brought in. And then there's also AB 2447 that establishes a rebuttable presumption for post-traumatic stress for a person employed by a private sector agency that's contracted to provide emergency medical services. So again, this was another bill that they've been trying to do stuff like this for a while, proposing bills, increasing the presumptions for cops and firefighters. This one would be to add post-traumatic stress for emergency medical services in the private sector, expanding it from just the public sector. Right now, it doesn't apply. It would only apply as of January 1st, 2021. So this bill, like its predecessor that I just mentioned, is only really there to, it could be expanded upon. It could be the framework on which an overall bill is ultimately decided, but we'll know in 60 days. And that's it, folks. That's our emergency presentation. I hope it was helpful. It's certainly a dramatic shift. Here's the information that you'll need if you want to take a look at our book or look at any of the webinars we've done thus far. There's the website and the other contact information. I wish you well. And again, this is a time for calm consideration. I advise everyone that is considering what to do under this law to slow down, don't panic, think carefully, seek advice of counsel, talk to people that you trust, and take the time to really consider long-term the implications of all of your actions, positive and negative. We can only do what we can do in the face of all this unknown, but we can make the best decision we can with the information we have in light of the values that we have in the situation we're confronted with. We as a firm and the other defense firms, I'm sure we're all here to help, and we will find a way through this together. And with that, I'll sign off and thank you for listening. Next week, like I said, there was not going to be me. It's going to be a webinar on return to work, which will involve our managing partner of the Employment Law Department and a real-time employer and someone with experience in claims, our executive director here, Janie Nethery. So I hope you enjoy that in our future webinars, and please feel free to reach out with any comments or questions. We always love the feedback, and we consider them carefully as we move through the webinar process. Okay, thanks for listening, folks.